In a valid contract, one person should be offering and another person should be accepting the contract. That is called offer and acceptance. Contract is nothing but it is agreement between the two parties where the parties will be bound to perform the rules and regulations formed under the Contract Act. There should be writing about the contract and the contract should be registered with the respective authority to call it as a valid contract. Hello everyone, I am Arun Kumar, lecturer in Department of Commerce and Management, Vidhyaashram First Grade College, the Temple of Excellence, Mysuru. Dear students, welcome to this new session on the subject Business Regulatory Framework. In this subject, in today's session, we are starting with unit number 1, which deals with Indian Contract Act 1872. Yes, dear students, in this particular session and in this particular unit, that is Indian Contract Act 1872, here we are going to learn about what is contract, what is agreement, what is acceptance, what is consent. Okay, so we are going to learn about the different aspects or the concepts which are relating to the contract. So when you are getting into a contract, so what and all you are supposed to look into, and who can get into contract, who is eligible to get into contract, and what and all the conditions we have to get into contract. So this and all we are going to learn in this particular subject or in this particular unit. So here the meaning of contract. So what in general we can say the contract? The law of contract in Indian Contract Act 1872. Yes, the law of contract in India contained in Indian Contract Act 1872. That means whatever the law we are following with respect to contract, we are following the rule of Indian Contract Act 1872. That means whatever the rules are formed, whatever the principles are formed with respect to contracts, that we follow under Indian Contract Act 1872, which is based on English common law. Yes, so Indian Contract Act is based on the English common law. It extends to all India except the state of Jammu and Kashmir. Yes, the Contract Act is applicable to the all India. So all India, like whether it's Karnataka, Tamil Nadu, Delhi, Gujarat, whichever the state, but all the state people, they are supposed to follow the contract rules which are there in Indian Contract Act. It came into force on 1st September 1872. So the Act lays down general principles governing all contracts. Yes, this particular Act is applicable to all the contracts, whatever the contract it is, but it is applicable to all types of contracts, but not the rights and duties of the parties. Yes, here the rules and regulations are prescribed under this particular Act, but not the duties of the parties. So whoever getting into the particular contract, for them the rights and duties are not described in this particular Act. So the right and duties are decided by the parties themselves. Yes, here the rules and regulations are made in this particular contract, but the rights and duties of the parties are not mentioned. That is not mentioned in the contract. Those rights and duties should be decided by the parties themselves. That means the rights and duties should be decided by themselves, by the parties. So this is the meaning of contract in general. So if you look into the scheme of the Act, the scheme of the Act is about, the scheme can be divided into two main groups. So which are those two main groups? The first group is general principles of the law of contracts. General principles of the law of contract is the first group, and the second group is specific kinds of contracts, that is indemnity and guarantee, contracts of bailment and pledge, and contract of agency. So the scheme of the Act is divided into two, that is the general principles of the law of contract, and the second one is specific kinds of contract, that is under that three we have. The first one is indemnity and guarantee, contracts of bailment and pledge, and contract of agency. Next, the definition. So the definition of agreement. So before getting to know the meaning or the definition of contract, first we have to understand the meaning or the definition of agreement. So what is agreement? So an agreement consists of an offer by one party. Yes, the agreement is consist of offer by one party and its acceptance by other party. Yes, here we'll be having two parties in agreement. So who are those parties? One party who is going to offer and one party who is going to accept the contract or the agreement. So there should be two parties in agreement. So one party is going to give the consent and the another party is going to offer. Next, in other words, an agreement comes into existence only when one party makes a proposal to the other party and that other party gives the acceptance. Yes, the first thing is, in agreement there should be two parties. One party should be offering and another party should be accepting. And in other words, what we can say, an agreement came into force. The agreement comes into force only when one party makes a proposal. One party should be there to give a proposal. Sir, I am selling my property. Like that, it should offer. Okay. And the another party, that the party gives the acceptance. So if one party is offering to sell his property, the opposite party, that is another party, should accept that offer. Then only the agreement is fulfilled. And we can say it as a proper valid agreement. So this is the meaning of agreement. Next, acceptance of proposal. Yes, so one party is going to propose or is going to tell that I am going to sell my property, is going to give the proposal to another party by stating that I am selling my property. Next thing is acceptance of proposal. So here you can see, according to section 2 subsection E of Indian Contract Act 1872, every promise and every set of promises forming the consideration for each others is an obligation. Yes, here the another party is going to accept whatever the proposal given by the first party. The second party is going to accept that proposal, and every promise, that means whatever the first party promises, whatever the second party promises. So every promise and every set of promises forming the consideration for each other is an obligation. Yes, it forms a consideration. What is consideration? Simply will not sell the property. Okay, for some consideration, for some value, money value, for some worth of money, is going to sell his property. So it forms the consideration between the two parties, whether he is selling or whether he is buying. So it forms the consideration between the two parties and also the obligation between the parties. So now, what is agreement? Agreement is nothing but proposal and acceptance of proposal. So one party should be proposing, or he should tell the opposite party that he is selling something. The second party or the opposite party, what he will do, he is going to accept the proposal. Then only we can call it as a agreement. If there is only one party, you can't call it as an agreement. There should be two parties. Okay, there should be two parties to call it as a valid agreement. So now we got to know what is the meaning of agreement. That is, proposal plus acceptance of proposal is called agreement. Moving further, the meaning and definition of a contract. So now we got to know the meaning of agreement, right? Now, what is the meaning of contract? So a contract is a promise or a set of promises. First thing is, a contract is a promise made by someone or set of promises for the breach of which the law gives a remedy or the performance of which the law is some way recognized as duty. So here a person is going to promise to another person, and by the help of the law, that is the Indian Contract Act law, we are going to perform our duty, whether you are a seller or whether you are a buyer. So you are bound to that. If you are getting into a contract, then you are supposed to follow the rules and regulations according to the law that is under Indian Contract Act. In other words, a contract is an agreement, the object of which is to create a legal obligation. Yes, simply by words. If you tell someone by words, it will not be a contract and it is not valid. Okay, you're going to tell your friend that, okay, fine, dear friend, I will gift you a car. Okay, just by words you are saying, there is no any legal document. In future, even if you will not buy a bike for your friend, he can't sue a case on you, right? But if you are giving it in agreement paper by stating that, my dear friend, on so and so date I will buy you a bike, On that date, you are supposed to buy him a bike and it is legally formed. That agreement is legally formed. Your friend can sue a case on you if you are not going to buy the bike on the specified date. So that is why here we can say a contract is an agreement, the object of which is to create legal obligation. Yes, contract is an agreement between the two parties. Why we go to contract? Why we create contract? In order to create the legal obligation between the two parties. So the contract consists of two elements. Contract consists of two elements. So which are those? The first one is an agreement. Yes, that means what is agreement? Agreement means proposal and acceptance of proposal. So in contracts we'll be having two elements. The first element is an agreement. Second element is legal obligation, that is enforceability by law. Yes, both the parties are supposed to perform the whatever the duties they agreed to perform. That is called legal obligation. They'll be having the legal obligation to perform because they are into contract with the rules and regulations formed by the Contract Act. So a contract is nothing but it is an agreement between the two parties where the parties will be bound to perform the rules and regulations formed under the Contract Act. And it involves two elements, that is an agreement and the legal obligation, that is the enforceability by law. So contract, again, an agreement plus enforceability by law is called contract. Easily you can memorize. Agreement is nothing but proposal and acceptance of proposal. Contract is nothing but agreement plus enforceability by law is called contract. So according to section 2 subsection H of the Indian Contract Act 1872, an agreement enforceable by law is a contract. Yes, if any agreement is enforceable by law, that means if any agreement is rulable by law, that particular agreement will be called as contract. If you are registered your sale deed or your agreements or lease deed with the particular authority, okay, with the particular authority, then that particular transaction between you two parties will be called as contract because that is enforceable by law. The essential elements of a valid contract. That means we got to know what is valid contract or what is contract. A contract is nothing but agreement plus enforceability by law. Alva? So what contract or what kind of contracts are called valid contract? So if a person fulfills few conditions, then that particular contract will be called as valid contract. That means a eligible contract, and we can also call it as a legal contract. So the first thing is offer and acceptance. In a valid contract, one person should be offering and the another person should be accepting the contract. That is called offer and acceptance. In a valid contract, in a legal contract, there should be offer and acceptance. The second element, intention to create a legal relation. That means both the parties should be having an intention to create the legal obligation. That means whatever the rules and regulations are there, they are supposed to be ready to get into that particular legal obligation. Then only we can call it as a legal or valid contract. Next one, lawful considerations. Lawful consideration is nothing but both the parties should have the consideration according to the law. Okay, so whatever the law says, according to that they should have the consideration in that particular contract. Next, capacity of parties, that is capabilities of parties. Both the parties should be capable to get into the contract. So what is capable? Yes, they are supposed to be a majority, they are supposed to complete their 18 years of age, and they should be sound minded. Okay, these are all called capabilities or capacity of parties. Next, free consent. That means both the parties should give consent to get into that particular law. That means if one party gives consent and if another party won't give the consent, then it is not called a valid contract. Both the parties should give the consent. Next, lawful object. Yes, there should be a lawful object while they are getting into the contract. Next, writing and registration. Yes, there should be writing about the contract and the contract should be registered with the respective authority to call it as a valid contract. So they are supposed to write it in a writing, whatever the contract they are getting into, they should write it in very brief and they are supposed to register it with the respective authority. Next, certainty. Yes, certainty is nothing but they should be very sure that they are getting into the contract. And possibility of performance. So both the parties should having the wish to perform the contract. Both the parties should have their wish and consent to perform the contract. Next, not expressly declared void. So that means they should be ready to get into the contract and they should not violate any rules and regulations, and they should not say that in the future they'll not, or they're not given their consent. So these are all the elements which are required to call it as a valid contract. So the first element is offer and acceptance. Second one is intention to create a legal obligation or relation. Next, lawful consideration, capacity of parties. Next, free consent, lawful object, writing and registration, certainty, possibility of performance, and not expressly declared void. So these are all the elements of a valid contract, and this question may be asked main exam for 5 or 10 marks. Okay, in the main exam, they might ask this question for 5 marks or 10 marks. So very carefully study about this particular concept. Moving further, kinds or classifications of contracts. So based on the type of contract we are getting into, we are going to divide it into different categories. So on the basis of enforceability, of law, we are going to divide the contract into 5 types. First one is valid contract. Second one is voidable contract. Next one, void contract. First one is valid contract. Second one is voidable contract. Third one, void contract. Next, enforceable contract. And the last one is illegal or unlawful contract. So what is this illegal or unlawful? So where we are not going to following the rules and regulations which are formed by the Indian Contract Act. That is called illegal or unlawful contract. So these 5 are divided or classified based on the basis of enforceability. So first one is valid contract, second one voidable contract, void contract, unenforceable contract, and illegal or unlawful contract. Next one, on the basis of creation. So the first one is express contract, implied contract, and constructive or quasi contract. So on the basis of creation, we are going to divide it into 3 types, that is express contract, implied contract, constructive or quasi contract. Next, on the basis of execution. The first one is executed contract. When both the parties to a contract have completely performed their share of obligations and nothing remains to be done by either party under the contract. So executed contract is nothing but where both the parties are already performed their duties as per the rules and regulations, where both the parties already performed their duties. So here you can see when both the parties buyer and seller to a contract have completely performed their share of obligation. That means they already performed their duty. There is nothing remain to perform. So that is called executed contract. Next one, executory contract. When either parties have still to perform their share of obligations into, or there remains something to be done under the contract on both sides. That means here in executed contract, already both the parties they performed all the duties whatever they want to perform. But under executory contract, still they need to perform some more duties. All the duties were not completed. Okay, those kind of contracts are called executory contract. That means yet some duties are supposed to be performed, yet some duties are supposed to be executed. That is called executory perform. So in the upcoming session, we are going to study in depth or in detail about the types of contract, whatever we discussed. So in today's class, what and all we discussed? We discussed about what is agreement, right? What is agreement? Agreement is nothing but acceptance. Okay, the first thing is proposal and acceptance of proposal. One party should be proposing, okay, proposing something you want to sell, and the second party is supposed to accepting that proposal. That is called agreement. Okay, next what we studied, what is contract, right? So what is contract? Again, contract is nothing but agreement plus enforceability by law. Agreement plus enforceability by law is called contract. So easily you can memorize. So what is agreement here? So agreement is nothing but, the first thing is proposal plus acceptance of proposal. Proposal plus acceptance of proposal, that is P, that is proposal plus acceptance of proposal. So A equals, in a very easy format you can learn it. A, agreement equals P plus AP, that is proposal plus acceptance of proposal is called agreement. Next, what is contract? What is contract? So contract is nothing but agreement plus enforceability of law. Enforceability of law. So C equals A plus EC, that is contract equals agreement plus enforceability of law is called contract. So in a very easy manner, in a very short time, you can memorize these definitions, that is agreement and the word contract. Next, what we learned, what and all the essential elements which are required for contract. The essential elements required for contract. And we also learned the types of contracts we have on the basis of execution or on the basis of enforceability of law. So with this, I'm going to wind up this session. So I'll come up with few more new topics in the upcoming session. Until then, thank you all. Have a nice day. Namaste.